Hi, I'm Stuart Solwin, a defense attorney here in Scottsdale, and today I'd like to talk to you about what happens if you get a second DUI arrest in Arizona. Now, if you already have a prior DUI out of Arizona, you know that this state has some of the strictest DUI laws and punishments in the country. And unfortunately, that's even more true when it comes to second-time DUIs out of this state. You're going to be looking at even higher fines and greater mandatory minimum jail terms than you would for a first-time DUI offense. But before we get into those details, let's talk about what we mean when we say a second-time DUI. And the most important thing to know is that there's a time frame in Arizona to determine when a DUI counts as being a second-time DUI for purposes of that enhanced punishment that I just mentioned. And that time frame is 7 years. So if you commit a second DUI within 7 years of committing your first, it can be punished as a second-time DUI under Arizona law. And one thing to keep in mind when you're calculating that 7-year mark is that we're looking at 7 years from the date that the first DUI was committed. And that will usually be the same date that you were pulled over and arrested for that DUI. So here, we're not looking at the date that you pled out that DUI or if you went to trial when you were found guilty. We aren't looking at the date you were sentenced, and we're not looking at the date that you serve your jail time. The only date that matters is when the crime occurred. And so that 7-year period is going to be calculated from the date of the first DUI when it occurred to the date that the second DUI occurred. Now, this isn't to say that the first DUI can't be brought up at all if it's older than 7 years. If you go to trial and you lose on your second DUI, but that DUI was outside of the 7-year mark, the prosecutor can still bring it up and argue to the judge that you should receive a harsher punishment than the mandatory minimum for a first-time DUI because you have this prior criminal history. Now, the judge can take this information into account and enhance your sentence if he chooses to do so, but that's up to the judge, and he doesn't have to do that. Your defense attorney can argue, on the other hand, that there's all these mitigating factors which lessen the impact of your crime, and so it means that you shouldn't be get an enhanced punishment because of your prior. But that's going to be up to the judge. Now, this is different from a DUI that has occurred within that 7-year time frame. And for those DUIs, the mandatory minimum sentence increases so that the judge does not have any discretion, but has to give you at least the enhanced mandatory minimum sentence because it is your second DUI within the 7-year mark. So what is this enhanced sentence? Well, the mandatory minimum punishment that you'll be facing for a second-time DUI depends on your BAC levels, your blood alcohol concentration levels at the time that you were driving. So just like with a first-time DUI, a second-time DUI is split into 3 categories depending on that BAC level. These are called a regular DUI, an extreme DUI, and a super extreme DUI. A regular DUI occurs if your BAC is above a .08 or if you are impaired to at least the slightest degree by alcohol or a drug. Extreme DUI occurs when your BAC is above a .15, and a super extreme DUI occurs when your BAC is above a .2. And your BAC is going to be calculated by either a blood test or a breath test that the police officer gives to you the night you were arrested for the DUI. Keep in mind also that the only BAC level that matters is the BAC level of this second offense. So in other words, the DUI you are facing now, if you got a regular first-time DUI 3 years ago, which puts you in that 7-year limit, and your BAC now puts you in the super extreme range, you will still be facing a second offense super extreme DUI. It doesn't matter whether you had a regular, an extreme, or a super extreme the first time. That first DUI only matters for putting you in that enhanced category of a DUI as a second offense DUI. And then exactly your mandatory minimum punishment is determined by the BAC of this second DUI that you're now facing. So let's talk about the punishments for these different levels of second offense DUI. If you're facing a second time regular DUI, then the mandatory minimum punishment you'll be facing is 90 days of jail and a minimum of $3,000 in fines. For a second extreme DUI, you're facing 120 days of jail and $3,250 worth of fines. And for a second offense super extreme DUI, you're facing a mandatory minimum of 180 days of jail, as well as a minimum of $3,750 of fines. Also, you'll be facing driver's license consequences for a second offense DUI, and if you're convicted, your license will be suspended for 1 year. You'll also want to keep in mind that what we've been talking about are the mandatory minimum sentences. In other words, this is the lowest a judge can sentence you to if you are convicted. But all of these types of DUIs that we've just talked about are classified as Class 1 misdemeanors. And these type of misdemeanors have a maximum penalty of up to 6 months of jail. And the judge can always sentence you to any amount of jail time above the mandatory minimum sentence if you're convicted up to that 6-month mark. So what can be done if you've been charged with a second-time DUI offense? I know that in talking about just the mandatory minimum penalties, things can look pretty harsh. But as with any criminal charge, there's always hope to either beat the charge or to reduce the charge to something lower through a favorable plea negotiation with the prosecutor. And this can include pointing out such problems as issues with the chemical test that was performed on you to get your BAC analysis. Also, even if the chemical test that you received was functioning completely properly, most measurements of BAC have a 10% margin of error. So if the BAC reading in your case comes back on the cusp of a 0.08 or a 0.15 or a 0.20, then usually we'll be able to argue there's a 10% margin of error, which would make it difficult for the prosecutor to prove that higher DUI charge at trial. And we can use that argument to often get the charges lowered. Finally, there can be arguments to make that the prior DUI you have, even though it might technically be within the 7 years, that it's just too old to be used as sentencing enhancement, really for the interests of justice. Maybe you were at the 6-year mark or the 5-year mark, and you otherwise had a spotless record between then, and a plea can be negotiated which can give leniency and knock the charge down to a first-time DUI charge rather than a second-time DUI charge with all of those enhanced mandatory minimums. Now, of course, every case is going to be different, and so not every resolution to a DUI is going to be the same. But these are some strategies that I've been able to use in the past to get favorable results for my clients who've been facing significant time under a second DUI charge. If you're facing a charge like this and you'd like to speak with an attorney about what potential options you have to fighting this charge, then please give my office a call. We offer free consultations for criminal matters, and we'd be happy to discuss your charges with you and develop a strategy for how to best combat those charges so that you can get the best possible outcome for your case.